Now we are in slide number 15. And the courts empower appropriate governments to appoint inspector cum facilitator. I think this is again a new concept. It is more to avoid malpractices, particularly in case of inspection. So this so-called inspector has to now act as a guide, right? So he has to guide the employers as well as the workers about the whatever compliance provisions available in the code. They have to apprise the employers and the employees whenever required. And the first time, even when the non-compliance is found, he has to give them a chance, right? So he cannot straight away go for any penal action. Maybe from the second time onwards, it is possible. He can go for taking action, but not from the first time. And it empowers the appropriate government to determine the ceiling of wage limit for the purpose of eligibility for bonus and calculation of, again, as we discussed, for fixing the working hours under Factories Act, which is considered to be the dynamic factor. Similarly, here also this salary ceiling under bonus, both for determining the eligibility and for doing the calculation. This is also considered as a dynamic factor. So currently, you are aware, for eligibility for the salary ceiling is 21,000 per month for bonus, and for the calculation, it is to be calculated on 7,000 or minimum rates of wages, whichever is higher. That is the current position. But this power again is given to the appropriate governments. So the point is, again, it need not necessarily be the same quantum all across the country. It could differ from one state to another state depending upon whatever number is going to be fixed by the appropriate governments for bonus. So to cut it short, again, for determining the eligibility and for calculating the bonus, the ceiling need not necessarily be uniform. Across the country. It can change once the code comes into force. And it provides for graded penalty for different types of contraventions of the provisions of the proposal. Okay, first time itself, of course, they may let off. Maybe second time it will be some more severe. Then severity will increase for the third time. That's how it is now planned. Not only under this code, in other codes also the same thing. Now let's move on to slide number 16. It also provides for compounding of those offences which are not punishable with imprisonment. So if only the fine is prescribed, then again there is a possibility that that can be compounded and paid, so that the long process of judicial process need not be followed. Instead, they can just pay it, accept the guilt, and they can make the payment of fine, and they can go off. That is the idea. Just to make it simple. Again, as I said in the beginning, this may not be possible all the times, only for the first time. And it provides that where a claim has been filed for non-payment of wages. So in case of any non-payment of wages or non-payment of bonus, or less payment of wages or less payment of bonus, or in case of any unauthorized deduction, even if this claim is made by the individual employee, the burden of proof shall lie with the employer. Right? That is very clearly spelled out in the code. And the existing limitation period for claims. So in case of such claims, now they have to claim it within 6 months, or they have to claim it within 2 years. So for different claims, it is varying from 6 months to 2 years. Now that limitation is enhanced to 3 years. So suppose if I am paid less payment, then I have 3 years time to make a claim. Right? So earlier it was not the situation. It varies from 6 months to 2 years, but through the code, it is the limitation period is getting extended. So it is beneficial for the individual employee.